Once I was there and it was too much of
a contempt matter, my lord, kindly includes this tomorrow under the heading to be mentioned. My lord, reason is then the reconstruction can commence, my lord. My lord, kindly includes it tomorrow.
Lordship, may I permit it to? Lordship, one is appeal hearing and another one is bail in connection with appeal.
Lordship, correction.
Grateful,
What Lordship, the petitioner is the PSF personnel and posted at Jammu and Kashmir.
Lordship, may I be allowed to mention one matter, Lordship, for upgradation? Is it there in the monthly, Lordship, item number 458, Lordship? Lordship, the urgency is that, Lordship.
Yesterday, the entire monthly list was called. Where were you?
Lordship, so far.
Next time, what we will do is, we will communicate this order to the appellant in jail, that the lawyer is not present. All right. So when the monthly list is called, please be present.
My lord, may I mention?
Yes.
My lord, for the inclusion in the list,
As
Your Honor. Your Honor, I'm filing this. Your Honor, I'm filing this application for the relaxation of bail. Much of
yes. Yes.
Item 1, 2, and 3, my lord. I appear for the respondent Agurpara Jutmi.
For the appellant,
I'm
there is the CBI investigation order. This was stayed, and Lordship has continued the stay. But we want this because this is looming on us, so we want this to be set aside.
kindly grant us extension to file affidavit time to file affidavit, my lord. Just 2 weeks time.
We appear for some of the workers' union. We need some extension to file the claim.
Forgery application comes after the final hearing.
I am one of the parties that seeking
Affidavit and oppositions have not been filed.
No.
That's some extension for filing.
So let us give all of you 2 weeks time to file your oppositions, and Another,
reply because there'll be 10 oppositions coming.
so 2 weeks for
make
reply.
it
We'll
very
post
kindly.
this matter after 5 weeks.
Yes. And kindly make the
Once the pleadings are over, we'll fix a date for hearing and dispose it of. Generally,
Grateful, madam. Great,
we take up on Fridays.
great, great, great.
and the interim order will have to.
Uh, time to file affidavit in opposition is extended by 2 weeks. Reply, if any, 2 weeks thereafter. Matter will come under the heading to be mentioned 5 weeks hence.
I'm deeply
Grateful, madam. Deeply obliged.
Interim order extended is granted earlier is extended till 28th of February 2025. That covers it, I think,
5 weeks.
or until.
Deeply.
Deeply obliged.
Yes.
Item 4.
Yesterday, the report was not ready. This is the report. Lordship were directed to send the for the cyber crime cell.
Has it been taken up?
Yes, my lord. Taken up on 3rd January, my lord.
All right.
Cyber crime. And this is the PS from the police station.
Investigation report is placed on record. Investigation of the case has been transferred to IT Act offences have been added.
Yes, my lord. After the addition, thereafter, my lord, they taken permission for that sometime delay, my lord. On 3rd, it was transferred. 3rd January.
All right. In as per report, offences under Information Technology Act has been added, and investigation has been taken over by Cybercrime Cell, Barakpur, Police Commissioner. Investigation be conducted with due expedition and taken to its logical conclusion. Proceeding is closed.
One of the matter is disposed of, like.
Yes.
Grateful, Your Lordship.
Closed. Proceeding closed.
Item 5.
कुछ प्रॉब्लम हुआ है
তুমি তো আমাদের লেট করছো
तो देख रहे हैं
Lord, 6 years business relationship of TMT bars. Out of their bill raised time to time 139 crore, I have paid 135 crore. My lord, on the last occasion,
you have placed the
yeah, I have placed the papers, my lord, through an advocate. My junior went because, my lord, the surgery of this petitioner is going on today.
all for TMT
And for this state.
all
They are for
TMT
de facto.
yes
This is the IO's report, Lordship, to copies. IO said that petitioners did not go and comply with the order.
did not go and comply with the order. We'll ask the IO to go to their office.
No, Lordship, what I'm saying.
We want the IO to go to their office.
IO made a notice, thereafter lawyer
Notice,
came.
we have considered the materials on record. Petitioner contents. He made efforts to hand over the documents to the investigating agency. He is ready and willing to cooperate with investigation. Learned lawyer for the de facto complainant opposed the prayer and submit petitioner had not paid the price of iron bars supplied to him. Learned lawyer for state submit. Investigating agency issued notice upon the petitioner, but he had not submitted documents. We have considered the materials on record.
Documents submitted.
Very good. Issued notice and documents were submitted for verification. We have considered the materials on record. Petitioner's firm has a business relationship with the de facto complainant company for last 6 years. Gist of the allegation in the first information report is that the petitioner's firm had not made payments with regard to consignment of iron bars supplied to him. Allegations, prima facie, allegations at its height would disclose breach of contractual obligations. Petitioner has supplied relevant documents with regard to the transaction. Verification of those documents would not require custodial interrogation. Under such circumstances, we are inclined to grant anticipatory bail to the petitioners on condition petitioners shall meet the petitioner number 1 shall meet the investigating officer once in a week until further.
My lord, only one submission, my lord. His surgery is going on today at AIIMS, Delhi, my lord. Only that
All
part,
right.
my lord.
As and when necessary.
My clear.
In respect of both. In respect of both.
One is husband, second is wife.
One as and when necessary. Other is the wife. Whatever, if there is some clarification necessary, he will go and clarify. All clear.
My lord, 10, I am praying for till Monday because he is going to take the auto today.
No. He didn't turn up. Several attempts have been made. Kindly see the report, Your Lordship.
We have considered the materials on record. Petitioner had been handed over a vehicle. De facto complaint handed over a vehicle to the his vehicle to the petitioner for flying on hire.
No, lordship. Petitioner is he is a agent.
Ah,
Took money from the de
that
facto
is it. He purchased the vehicle, de facto complaint,
new vehicle.
on
I'll
a
have-
hire purchase
Yes.
and handed it over for you to ply.
No.
Now you have diverted the vehicle.
No, lordship.
3,30,000 rupees is there, Your
I
unpaid.
have to give him a new vehicle. I have to give him a
Not
new
taking the
vehicle.
calls of the inspector, Your Lordship.
Lordship.
All right. Petitioner, de facto complainant had handed over a vehicle to the petitioner. He has misappropriated the vehicle in spite of opportunity. He did not meet the investigating officer or hand over the said vehicle. In light of the nature of crime and the conduct of the petitioner, we are of the opinion this is his custodial interrogation for recovery of stolen vehicle is necessary. This is not a fit case to grant answer.
Okay.
Lordship.
Next.
I beg to appear for the petitioners, my lord. On the last date, my lord, I have delayed on 77 to 80 as per the application of the college which you.
Right.
Lord, there is a report was called for. In
I
the,
have received the report from the page regarding page 77. But when it so far as the further department from the web that RTI is, so that yet I have yet to receive.
Or like 2 weeks.
but in the meanwhile, the requisition filed by the wife of the de facto government was dismissed on the ground that she does not come with the clean hand before the court and the college having affiliation. Necessary affiliation.
That order has been
That
passed.
order, my lord, kindly spell it.
All right. Report is placed. Learned additional
Ask
public
current of
prosecutor
internal page.
seeks further time to submit report with regard to the authenticity of the documents showing petitioner's institution is affiliated with West Bengal Medical Council.
Sir, not,
In response,
not medical, my lord, nursing.
West Bengal Nursing Council. Sorry. However, petitioner's counsel places on record
Last file.
uh, order passed by a learned honorable judge of this court in WPA 181 of 18120 of 2024, wherein writ petition of the de facto complainant was inter alia dismissed on the ground that she had falsely alleged the institution was not affiliated to West Bengal Nursing Council. The said order has not been assailed by either of the parties. Under such circumstances, we are of the view we hold there are prima facie materials that petitioner's institution was affiliated to West Bengal Nursing Council and there was no deception practiced on that score. De facto complainant's allegation that that the institution did not give her a refund after she had withdrawn herself from the course is a matter of breach of contractual in this backdrop is a matter of breach of contractual obligation which would not call for custodial interrogation. Accordingly, we are inclined to grant anticipatory bail, meet investigating officer once in a while.
From the other department, I have verified. But this is a report that they are under
But
that.
nothing more is necessary.
My lord, two things, my lord. First, my lord, the writ petition was filed by the wife of the de facto complainant. And my lord,
I will clarify that. That the report.
Additional public prosecutor submits report. এই করে দাও আর he seeks time to take further instructions in the matter.
Take 48 of the case.
What is 40?
That is the RTI report.
RTI is not necessary.
But
When
the
there
that
is,
was issued by the director of health services, nursing branch.
if it is affiliated, end of story.
my lord, one more thing, my lord. So far, the refund,
Petitioner's mother, de facto complainants,
the wife
mother.
of the de facto complainant is the writ petitioner.
De facto complainants,
Wife of the de facto complainant.
wife. It's a male.
The writ petitioner was the student. The husband has filed the complaint.
Okay. De facto complaint, the candidate বলে দাও, হ্যাঁ? Victims writ petition.
My lord, so far the refund of my lord, that thing is also my lord made clear in the writ petition that that is not permissible in the as per the rule. Relevant rule.
The allegation in this background allegation has to be assessed in the light of relevant rules and even if believed would constitute breach of contract. Next.
My lord, your lordships were pleased to direct intimation to the victim on the last occasion. My lord, the allegations of promise to marry My lord, the allegation is very peculiar. Lady herself is saying that she was having relationship for 2 years with the son of her husband's elder brother, and thereafter she remained absent for 7 days with him. And my lord, in order to explain her absence, perhaps it appears, my lord, this has been given. And my lord, there can't be any promise to marry because she knew that subject to
Herself is
kind.
a man.
Yes, my lord. Mother of 2 children.
Petitioner submit, victim was a married and adult lady. Allegation of cohabitation on false promise of marriage is patently absurd. He prays for anticipatory. Learned lawyer for the state submit. Petitioner is the nephew of the victim lady. He gave false assurance and cohabited with her. Well, nobody appears on behalf of the victim. We have considered the materials on record, including her statement. In her statement, victim admits she is a married lady. However, admits she is a married lady. Intimacy between the petitioner and the victim was due to love and affection. Appears to have arisen out of love and affection and not out of love and affection, full stop. In this background, we are of the opinion custodial interrogation is not necessary and petitioner may be
Grateful, my
granted
lord.
answer.
My lord, I am for the petitioner. My lord, allegation under section.
Been made by
50% of final bill for unmetered consumption to the tune of so and so, adjourn 2 weeks. 50% deposit in the meantime,
My lord, kindly make it 3 weeks, my lord.
3 weeks. Next,
Here also final assessment has been made, 1,69,000.
same order, 1,69,000, 3 weeks. You are there.
Yes, my lord, I am there.
Next,
As for WBC, they say, well, the allegation is under section 138. Well, here the connection was in the name of the father. After his death, Malad, there was an outstanding of rupees 3 lakhs, 1,000 and all. Malad, he without any permission, Malad, he board went there and disconnected the connection. Thereafter, he reconnected.
let him pay 50% of the outstanding dues. Petitioner
9,866.
Petitioner undertakes to deposit 50% of the outstanding dues payable by his father.
Father has expired, man.
Outstanding dues raised on his father, bracketed since deceased, in adjourned 2 weeks.
Can there be any, this was 2 weeks, 3 seconds. Can there be any interim protection?
Why? They will protect you. You pay 50%, they'll be very happy to see you that you don't.
No, police is chasing that. Is
Police, tell police that he gets certificate from electricity whether you will arrest or not.
great news. 50% payment.
My lord, I'm for the petition. Under section 147, 148, 326, 307, 427, and 34. The petitioner is a teacher. Charge is submitted against the 16 accused person. My lord, kindly come to kindly see the affair, the last para. বিকেল 5টার দিকে সকল অভিযুক্ত লাস্ট প্যারা আপনার নিকট হতে অভিযোগ দায়ের করিতেছে অভিযুক্ত ব্যক্তিরা আমার প্রতিবেশী বা লোকজন সঙ্গে উঠে আসিয়া তাদের গ্রামের লোকজন ভয় পায়। পূর্ব রাগ ও হিংসাবশত গত ইংরাজি 16/2/2024 আনুমানিক বিকাল 5টার দিকে সকল অভিযুক্ত দলবদ্ধ হয়ে আমার বাড়ির সামনে জড়ো হয়ে অসভ্য ভাষায় গালিগালাজ করে। এন্ড লাস্ট বাট ওয়ান লাইন, উজ্জ্বল মন্ডলকে তারা বাঁচাতে এলে 2 নম্বর অভিযুক্ত ব্যক্তি তাকে লক্ষ্য করে বোমা মারে। That my lord, kindly that accused number 2, the affair name is the Sunil Mondol, the who threw the bomb.
My lord, petitioner number 1, the petitioner before your lordship is the FIR accused number 1. 9th line from the bottom of the same paragraph, my lord. Assaulted with a panchi. Bomb recovered from his house.
No, bomb
absconding.
My lord, kindly see the উজ্জ্বল মন্ডলকে বাঁচাতে গেলে 2 নম্বর অভিযুক্ত ব্যক্তি তাকে লক্ষ্য করে বোমা মারে। মানে স্পেসিফিক অ্যালিগেশন এগেইনস্ট the FIR number 2 সুনীল মন্ডল।
1 নম্বর অভিযুক্ত ব্যক্তির হাতে থাকা পাসলি দিয়ে আমাকে
উল্টো দিক দিয়ে কোপ মারে। হাউ ইজ ইট পসিবল? উল্টো দিক দিয়ে কোপ মারে। and also last but one line,
আমার পিতা গুরুচন্দ্র মন্ডলকে মেরে ফেরার উদ্দেশ্যে তাকে লক্ষ্য করে বোম মারে। বোমের আঘাতে গুরুতর।
2 নম্বর অভিযুক্ত ব্যক্তি তাকে লক্ষ্য করে বোম মারে। The petitioner,
where 2 নম্বর?
2 নম্বর সুনীল মন্ডল, the FIR name সুনীল মন্ডল।
Where is that? তারপর আমার পিতা সোয়ানসো কে, that is 1 নম্বর, 2 নম্বর।
No, my lord.
Where?
উজ্জ্বল মন্ডল তাকে বাঁচাতে এলে 2 নম্বর অভিযুক্ত ব্যক্তি FIR name the সুনীল মন্ডল।
Correct, that is next stage.
Next stage,
2 bombs are thrown. 1 bomb at Gurupodo, and then when Gurupodo is sought to be protected by Ujjwal, second bomb. So we are dealing with both bombs.
Actually, petitioner is not throwing any bomb. The petitioner,
We don't know. But the FIR says he threw a
the
bomb.
allegation against
Correct.
the petitioner is a teacher.
Anticipatory
This is
bail
actually
allegations, there are
omnibus
Guru-
allegation
Guru-
just because the 16% is
One
there,
second.
my lord.
Guru Chand suffered injury.
Yes, my lord. Page 62 and 63 of the case diary. He is in fact a teacher, my lord, but a politically involved and multiple states.
That's why he is involved. There is a
Multiple
political involved. That's
multiple
why the
statements
petitioner
say,
is
my lord,
involved.
that
The
he has
petitioner is
been-
a teacher.
Why bring politics?
My lord, he has
Yes,
been
my lord.
creating
You are
ruckus in the
absolutely right.
locality. Ruckus in the locality.
You are absolutely right. There is the political implicated.
Multiple statements, my lord.
There is a teacher.
Of all the
He has not
witnesses.
thrown any bomb.
He has
No.
been.
This is the allegation.
Petitioner contents he is a teacher and has been falsely implicated due to political rivalry. He prays for anticipatory bail and a lawyer for the state opposed the prayer. We have considered the materials on record. In the FIR, it is alleged that petitioner had assaulted Gurchand Mondor with a parsley and had assaulted de facto complainant with a parsley and thrown bomb at his father, Gurchand Mondol. Injury report of Gurchand Mondol shows bomb blast injury. In light of the aforesaid incriminating materials and nature of a crime, we are not inclined to grant it.
Grateful.
Pursuant to your lordship's direction, my lord, on the last occasion, the earlier bail application, my lord, there was an allegation that documents were forged. We have taken instructions from the client. The documents appearing from page 17 onwards of the earlier application, that was not pressed, my lord. Those documents were handed over to the person who sold the affidavit, who is the third accused person. And through him, the documents were handed over. Those were attached by the person. But these petitioners, whatever documents these petitioners have, that has already been submitted before the IO. There is a seizure list to that effect, my lord. On 1st of August 2024, when you was called to join investigation, they have appeared and they have handed over those documents.
They were all together. We indicated to the investigating officer that whatever documents have been, sorry, madam. Fifth July. Fifth July. But this was June. Yes. 5th July we indicated.
July document.
5th July we indicated that June is going to these are sorry.
Please file.
Affidavit is a part of the case diary. My lord, we'll cause an inquiry to this.
Please file a report. Which affidavit?
Not the one which they are alleging to be forged.
Page number
Yes.
17 of item. Page number 17 of item number 21.
Annexure 2.
Annexure 2 as well as all documents annexed.
That is the
Aadhaar card and everything, we've got everything.
Petitioners have taken out a second application for pre-arrest bail. They contend the earlier application was withdrawn as not pressed. Per contra, Mr. Banerjee, senior advocate, submit. Petitioners had approached the court earlier for similar relief with unclean hands. They had annexed fake and forged documents in support of their plea. When the issue was raised, when this, in view of the aforesaid, when this issue was brought before the bench concerned, the petitioners withdrew the application. In light of the aforesaid submission, which relates to use of fake forged documents in an earlier bail application dealt with by another coordinate bench, we considered it prudent that the present application be heard by the same bench. Yes. Let their lordships pass appropriate orders. Let the matter be placed before the Honorable the Chief Justice for appropriate direction. If that is so, in our understanding, if we were there, we would have registered an FIR against these clients. The directed registration of FIR. So, since it has been considered by the coordinate bench, the judicial propriety demands that this matter should be heard by them because it needs a clarification. The order is not clear.
Grateful.
The present captain.
Next, 22.
It's a case of 467, 468. Well, a disputed deed is of 1990. That is 34 years back. My father
registered
deed. My father, registered that.
Right. Petitioner
This is not the deed, your lordship. Using this deed number and the date, he has forged a deed and mutated his name. He's saying that the complainant he has purchased the land in 1990, whereas the title of the complainant has come in 1998.
Yes.
There is a civil dispute. Petitioner submits that he had procured the land. He had purchased the land from the de facto complainant.
No.
Or third party.
My father purchased the land from one Abdul Quddus in 1990.
And de facto complainant.
De facto complainant is 98.
Purchased from him.
Yes, my lord. Kindly see the deed, my lord.
Forged the deed saying that he again purchased it back from me.
No. My lord, kindly see the FIR. My lord, kindly see the FIR for once.
Because his custody interest.
The registered deed.
No, his deed is not registered deed.
1990 deed, my lord, I have annexed.
And 1999 deed is registered, which
he sold to the de facto complainant. He sold to de facto complainant in 1999.
1998.
Or whatever. 98 or 99. He claims his title from his father who purchased the property through a deed in 1990.
He purchased the property along with his brother and sister.
My lord, in 1990, I was minor. My lord, my father on behalf of three brothers. My lord,
so why don't you clarify when you start speaking why half truths my father purchased? First say that you purchased, your father, he was a minor and your father represented you.
Yes.
You are the holder of the title to the land in 1990.
In 1990.
98 you have sold it to the de facto complainant.
This is his allegation.
You say you have not.
No. That is why they applied before the BLRO for the transfer.
98, the purchase is by a registered instrument.
My lord.
My lord, kindly see the 98 deed for once. Then, my lord, I will make my
instrument or not?
My lord.
It's a registered.
Yeah, my lord, well, kindly see.
Now, what he says that he has repurchased it.
Yes, your lordship. He says that he has repurchased it, and on the basis of that forged deed, he has mutated his name, your lordship.
Right. Repurchased it in what manner?
It's a forged deed.
What do you mean by a forged deed? Is that registered deed or not?
It has been never been placed before the register, your lordship.
So it is not a deed at all.
My lord.
So,
it's not a deed.
So if someone, listen to us, if someone is so naive enough to take a sheet of paper showing transfer of immovable property as a purchase, it has no legal value. Petitioner submits that his father had purchased the property in his name in 1990. De facto complainant has made a false claim on the property and lodged the present case. He prays for anticipatory bail. Learned lawyer for the state content, petitioner had transferred the property to the de facto complainant by a registered instrument transferred in 1998 by a registered instrument. Subsequently, he prepared a forged document to show that the property had been retransferred. We have considered the materials on record. Petitioner contends his father had purchased the property in his name in 1990. Full stop. Subsequent prosecution, de facto complainant contends that the property was transferred to him in 1998, but petitioner claims title to the property through retransfer. The issue relates to title in property and may be adjudicated at the appropriate stage of the proceeding in an appropriate forum. Document, purported forged document, a unregistered deed, is already in the custody of investigating agency. Custodial interrogation, it is trite. An unregistered document does not transfer title in an immovable property. Hence, no wrongful loss can be said to be caused by the unregistered instrument. Be that as it may, custodial interrogation for progress of investigation is not necessary, but petitioner requests to cooperate with investigation and hand over his handwriting / signature if necessary. Meet investigating officer once in a week. Next.
May it please your lordship. Lord, I'm for the petition. Lord, yesterday, your lordship, my lord, I had submitted, my lord, this is a case registered under section 420, 406 in the complaint against two registered mobile numbers. Now, my lord,
Yes,
so
yes,
far,
Mr. Nondi, what is his connection?
On an online platform.
That we have understood. What is his connection?
His connection, right? Two companies we could, he got a notice that two companies, namely Mamoni Enterprise.
The complainants' personal documents were were accessed on a platform claiming to give him a loan. Now that was utilized to set up GST accounts, and money was
fake invoices were generated. Two companies, namely Mamoni Enterprise and Das Enterprise. When we got the details of those two companies, Mamoni Enterprise, the account is in name of Bengal Benami Center, and this Das Enterprise, its account is in SM Consumer OPD Private Limited. The role of this present petitioner, when the banking accounts were taken, there were transactions. Invoices were created between Das Enterprise and the petitioner being the proprietor of one Shai creation. There, those invoices shows that there were goods were supplied, delivered. This by way of that 3.88 crores of GST they have incurred.
Siphon.
The total amount of GSTs in these two companies is around 21 crores.
no, that is the turnover that has been alleged. I'm sorry.
So
what they have got? Input credit. They took input credit.
Creating fake invoices.
Right. So they say, Das and Mamuni say that they have supplied goods and to
Sai.
Das Enterprise.
Das says they have supplied goods
to Sai creation.
To Sai, and that credit, input credit, they have taken. And Sai creation has claimed that has paid that amount. That supply is also fake.
Fake.
Yes.
My lord, so far as this petitioner is concerned, my lord, he is engaged, my lord, this proprietorship firm, he is engaged in spare parts. Now, my lord, candidly, I am submitting. My lord, this petitioner, my lord, had purchased materials from that, but he is nowhere aware of such.
Mr. Amit, the extent to which your exposure is there, if you can deposit that amount.
Yes, that is what I'm saying. Now, so far as that input is concerned, my lord, I'm going to reverse it back as well as GST.
Please reverse it and come.
Yes, ma'am.
He will reverse the input, huh?
But so far as the other things, I was given.
Don't have your lecture on other things. Reverse the input so that the government exchequer loss.
I'm grateful, deeply grateful.
Without prejudice to his rights and contention, petitioner contends that his firm would reverse the input credit allegedly fraudulently availed of.
Yes.
Within.
Thinks Das Enterprise is the person where invoices were generated.
Only Das.
The account linked with Das Enterprise, the KYC details were taken. Now that KYC detail shows that that account number is of SN Commerce OPD Private Limited. So when Das invoice and give that this invoices, whatever has been created, on the basis of which the account number, this banking account number which is there in between them, but that account is belonging not to Das Enterprise, it is of someone else.
Right.
So this account number itself is a fake one. But
Whose
the
account
business account number of Das Enterprise.
Is Das Enterprise created by Sai?
No.
Not created by Sai. Now, Das Enterprise, you said Das Enterprise is a fictitious entity.
But Das Enterprise is a fictitious entity.
Now, whose account was utilized by Das Enterprise?
But invoices were generated.
I can show it.
No, invoice is one thing. Where was the money being credited on behalf of Das? Where was the
SN Commerce?
Who is this? Who is this SN Commerce?
It is belonging to one Sweta Jain.
Who is Sweta Jain?
She is the proprietor of that company. KYC shows that Sweta Jain is the.
Who is Sweta Jain?
My lord, I'm not aware of.
Then go to custody.
No, my lord, may I?
Mr. Ahmed, either disclose the identity of the person who is behind the facade of Das Industries, or go to custody, because we have to find out exactly where the person, the brain exists in creating this money trail network. You understand how the money trail network has been created? First, data has been theft. It's a case of data theft. After data theft, fictitious facades created, shell companies created, and transactions shown, and input credit siphoned away. You are one of the entities with whose identity is utilized to show supply and thereby generate input credit. Correct? So you definitely know who is the person who generated the input credit, because your portal will be showing that XYZ Das is taking input credit in respect of supply.
But I have the document with me. I will just like to show you, Lordship. It's to Downa Joshua. Well, let's see is, in the market, what is happening. I'll tell you honestly, my lord. My lord, they generate bills in purchase. Now that is wrong on his part. I have purchased materials, my lord, to get in order to the
end of story. If you make false bills, end of story.
No, I have not made. This was given to me. This was given to me, my lord. It is not that I have, but this I will reverse it back. This I will reverse it back. This is my, I admit. Yes, if I've taken an advantage in an input,
whatever, we have understood. We want to know the identity of the person who is behind Das.
Then, my lord, may I pray for one thing? My lord, let me appear before the investigating officer.
Let him explain. Let him explain the identity. Adjourn 2 weeks. Petitioner shall cooperate with investigation.
And my lord, only one thing, my lord, because I would not have.
In the meantime, if you reverse, you reverse.
Yes, I will reverse it.
We are not passing any order.
And that, my lord, one more thing, my lord, because my lord, they were seriously after me.
He can always reverse.
I will cooperate. I will go. Whatever your lordship, my lord, says. But only thing, my lord, finally protects me, no coercive measures. Otherwise, my lord, I will go and tell everything. whatever has happened so far as these documents are concerned, I have procured, this was given to me, not.
No, we have, we don't know.
Is a fake one.
Correct. We know thus is probably the fake one. Now the thing is, he may have
I'm also
intimation with regard to the person who is operating on behalf of Das. It is your duty. These do not require, Mr. Nondi, these do not require any interrogation. It only requires tracing of the flow of the money in the accounts and the identity of accounts. So KYCs, etc. will show if they are masked by using KYCs which have been stolen. Then who is the person? The documents signed, the IP addresses from which?
But we have found at least there are 30 transactions
To
between
give us a
Das
better.
and Shine. Now, the existence of
You are only gunning Shine. We are saying if Shine is the person who created Das, tell us that. Or let Sai disclose who is the person with whom he interacted in the matter of the ITCs which were credited through Das. Right? In an ITC, the credit is given to him because Sai is going to make the payment. It's a value-added tax, sir. So nobody takes away anything. Did Sai make the payment? He will say it's a fake account. There may be two things. Sai may be foisted, like there is data theft with the complainant. Sai may be an entity was wholly unaware of these transactions being generated in its name. But for that, person who is operating through Das must know the GST, what number, that IN number, GST IN number of Shine. Okay. These are things, Mr. Nondi, all these just amount. We want clarity. One by one. Why you say Sai should have known? First, GSTIN. How does Das know GSTIN of Sai? Number one. Now, this question you have to put to him. And come back after 2 weeks.
But only I was praying not to take any coercion. But twice, they have been to the. They are after.
We know what they will do.
Kindly,
let him meet the investigator.
I will. Kindly
Mr. Ahmed, we are not passing any order, but you are under our supervision in this process. All right?
I'm good.
Don't worry. Come up with clear facts if you want to save your liberty.
Yes. I'm grateful. Deeply.
2 weeks. We keep this on 5th. 5th.
My appearance maybe.
Your appearance.
If required, I will.
You don't require anything.
And only thing which I was thinking, if he's claiming to be so innocent, availing loan, I should not have said this. But it might be a case where he is being protected by the investigating officer.
Let us see. This is not at all a case of protection, Mr. Ahmed. Don't put your case too high. He is a victim of data theft. Yes. Correct. From the data theft comes the pilfering of the government taxes.
What I have come to know, sorry, subject to correction, but these people, they intentionally do this by taking some advantage. What I have come to know.
Who does?
These people.
Which people?
The person who has complained. They get an offer that you create. And normally they get an advantage of these GST inputs. Anyway, I'm sorry.
They're very poor persons for sure.
That is why it happens. They are very easily targeted.
That is all right. That is all right. They may sell their Aadhaar card for 50,000 rupees. But you are in an involvement of siphoning of GST funds over crores.
imposing the liability on us.
I'll come back, my lord. Grateful.
And meet investigating officer as and when necessary.
Grateful. Deeply obliged.
Gravity nature.
My lord, I'm the petitioner. In this application, my lord, I'm leaded by Mr. Shankarnath Mukherjee. My lord, in this matter, I'm leaded by my senior Shankarnath Mukherjee. My lord, in this application,
Injury. We have considered the materials on record, allegations of torture are general and omnibus, medical report, outraging of modesty by petitioner is the husband, and the allegation of outraging of modesty does not apply to him. Under such circumstances, we are inclined to grant answer.
much obliged.
Meet investigating officer considerably. Next.
And for the petitioner led by Mr. Munshon Chattopadhyay, my lordship.
Abetment, suicide.
2 years of relationship. After that, the accused got job in the as a constable in the Kolkata police. Thereafter, she cut off relationship. He insisted on that.
Oh, this is a lady. The man commits suicide.
Yes.
What is the suicide note? Let us see.
My lordship, she never denied to get married. She just asked for some time till the confirmation of this job.
इसका लाइफ खत्म
In his death note with a lot of photos and all.
So, what is his problem if he doesn't marry?
He couldn't bear it. The separation, the pangs of separation.
First, section 69 is not gender neutral. It is a woman-centric protection. Petitioner is a lady. She had friendship with the deceased. After obtaining, subsequently the deceased, subsequently she got employed in West Bengal police. She got employed. Subsequently, the deceased committed suicide, and petitioner was implicated in the case. She prays for anticipatory bail. Learned lawyer for the state submit. Petitioner refused to marry the deceased. As a
My lordship, he never refused.
We know. We will record your submission. Marry the deceased, and as a result, he committed suicide. He has left behind the suicide note implicating the petitioner. We have considered the materials on record. There was materials on record which show free mixing between two consenting adults. Petitioner obtained job in West Bengal police. In the suicide note, victim claims that petitioner changed her stance after obtaining job and refused to continue the relationship. Whether this conduct of the petitioner would constitute abetment to suicide requires to be assessed at the appropriate stage of the proceeding. Now, learned petitioner's counsel submit petitioner had merely sought time to formalize the relationship and not refuted it. Be that as it may, whether conduct of the petitioner would be assessed at the appropriate stage of the proceeding. In custodial interrogation for progress of investigation is not necessary and petitioner may be granted answer.
Anti-suit
27.
Now it has become elusive.
My lord, I'm
Elusive.
After 1909 order,
Ah,
Supreme Court has not yet passed any order after that.
then
But they raised a
serious. Why should it?
My lord, I am praying for not this week.
Why?
Mr. Antoriko Basu is appearing in this matter. He is suffering from severe
5th of February.
Lordship, I am appearing for the petitioner, Lordship. This is a dispute relating to property between the family members, Lordship. There have been cases and counter cases between the parties. Lordship,
We have considered the materials on record. There was a fight between family members. There is a dispute over property amongst family members. This ensued in a fight. Injuries are not grievous. And whether the injuries are grievous or life-threatening may be assessed at the appropriate stage of the proceeding. Keeping in mind the aforesaid facts, we are inclined to grant that.
deeply obliged, Lordship.
Next.
Item
number 29, I'm for the petitioner. Item number 29, I'm for the petitioner. My marriage, my lord, my wife committed suicide by hanging, my lord, at her parental home, my lord. My lord. Thereafter, my lord, what has happened? Hearing the incident, my lord, I was in Bangalore, my lord, working in a company, my lord. On 4th November, my lord, I returned back to home, my lord. In order to save themselves, the parent, father-in-law of the petitioner, my lord, lost this instant case, my lord.
She was only 13 years old.
15 years old, my
Correct. We have considered the materials on record. Victim was a minor girl. She was tortured by the petitioner and her in-laws. As a result, she committed suicide within 2 months of marriage. Petitioner contends he was working. He contends at the material time he was working at Bangalore. He was working at Bangalore, and victim had committed suicide at the parental home. These arguments appear to be.
Well, I have annexed a document, my lord, page 13, annexure C.
What document?
My lord, this shows, my lord, the document of a company, my lord, that
we are not disputing. These arguments are flimsy, as victim had been subjected to torture continuously prior to the incident by the petitioner and her in-laws, which compelled her to take refuge at her parental home where she committed suicide.
She was staying at her parental house.
Presence of the petitioner at the place of occurrence, which compelled her to commit suicide. presence of the petitioner at the place of occurrence is not necessary in light of the is not necessary in view of the allegation of abetment to suicide, in view of the allegation of continued torture during the brief matrimonial life leading to suicide. Accordingly, we are not inclined to grant answer.
Grateful. Recorded now.
No. But service not complete, 30.
1 week.
30.
31 week.
Same, 31 also same player.
30, 30. $32.
32 malar 4.
না রে বাবা, same. হ্যাঁ, তা নাহলে আবার 1 week কেন আছে?
Malar 4 years after marriage, I am the husband. Malar 498 to 300.
If the injury report means taxes has been submitted, there are 3 statements of the neighbor. They say that he used to beat up his wife, demand for dowry.
Sand. We have considered the materials on record. Petitioner demanded dowry and beat his wife. Ocular statements are corroborated by medical evidence. Under such circumstances, we are not inclined to grant answer. Next.
Well, the allegation is that I have applied a variation certificate where the signature of the member was forged, but nothing was gained, my lord. My signature.
Kindly come to page 5, that is the statement of the de facto complainant lordship. Also, the statement of the signature has been sent to the QTEB.
No transfer took place, right?
No.
On the basis of the variation certificate.
It's been issued in favor of the
Has the variation certificate been acted upon? Not. Variation certificate is with you. Let him supply the signatures to you. Petitioner contends that the alleged forged variation certificate, variation one is inheritance, bracket certificate had not been acted upon. No wrongful loss was suffered by de facto complainant. He prays for anticipatory bail and a lawyer for the state submit de facto complainant's signature in the variation certificate is forged. We have considered the materials on record. Forged document is in custody of investigating agency. No it was not acted upon and no wrongful loss had been suffered. Under such circumstances, a petitioner undertakes to supply his signature and handwriting for verification. Under such circumstances, we are inclined to grant anticipatory.
Certificate is with you. It has been issued in his favor. It has not yet been taken back.
No, variation certificate is issued, but the signature is in the records.
Yes.
Variation certificate, let the variation certificate be delivered. Can you collect the ones?
I'm liftable.
Next.
May please, Your Lordship. But the husband of the complainant was having an affair with one Sumitra Singh. They were caught at night together. Vijay Singh, one of the co-accused, along with me, went over there. Vijay Singh assaulted them with knife. I am
to custody. We have considered the materials on record. Street vigilantism is not appreciated. But street vigilantism is not appreciated. You are not moral guardians. We have considered the materials on record. Petitioner had assaulted the victim, resulting in grievous life-threatening injuries.
Assault is
accordingly, we are not inclined to grant anticipatory bail. All these local moral guardians of the society, all in jail. Radha.
Sections are 85 and 108 of BNS.
Not to them.
Well, service is not.
Notice.
The only thing is, the victim is
Be a petitioner. My lord, petitioner is the brother-in-law of the de facto complainant. The affair was lodged after 5 years, my lord. Couple occurred between the family of the de facto complainant and the petitioner family in the house of the petitioner, my lord. Petitioner was falsely impregnated. Other co-accused also granted bail.
Settle the issue, Lordship. There they were assaulted. And
the wife
and his brother. By this person, Sagar Ali.
Okay. You have considered the materials on record. De facto complainant is the petitioner's sister-in-law. There is a matrimonial dispute. De facto complainant and mother came to the petitioner's residence for settlement. Petitioner had assaulted them. Ocular statements find corroboration with medical records. Under such circumstances, we are not inclined to grant anticipatory. Next.
The service is not complete, man. Next time.
64.
Yes, well, 69. 69, my lord.
All right. 1B.
Great, my lord.
Next.
My lord, only indulgence through PS, my lord. Service. Great.
39.
This NCB is the opposite party.
Give notice
No.
tomorrow.
No, notice to in additional
Additional notice upon nobody appears for Union of India. Notice be issued upon the additional solicitation.
Great.
Next,
Madam, I'm for the de facto complainant. I'm for the state.
tomorrow.
302 named in one.
Listener,
I'm for the de facto complainant.
Prayer for anticipatory bail of two co-accused.
we have
persons
considered
that
the
has been
materials on record. Statements of
WPS
eyewitnesses implicate the petitioner in the murder. Prayer for anticipatory bail of co-accused had been turned down in view of the aforesaid facts, gravity of offense, and prima facie involvement of the petitioner in the crime. We are not inclined to grant anticipatory.
Grateful, Lordship.
Next.
41 to 43, my lord.
Forty-six, 47. Well, at number 45, there's an application for bail in connection with appeal. Is in custody for 13.5 years.
So Lordship was pleased to call for a report on an earlier occasion because earlier there was Mr. Mitra and Mr. Ganguly was appointed.
By your lordship, my lord.
Uh, some Rima Kumar had filed an application, making an application for suspension on behalf of Ajay. Report was called for whether she was to continue. She is appearing on and off. She's not appearing
Where
regularly.
is she?
On the last occasion before Justice Sen, Justice Sen had observed that since she's not appearing, therefore Mr. Ganguly will represent the appellant in the meantime.
So far as my lord Mili Pal is concerned, I gather that she has sent a letter says that she will appoint her own lawyer. She does not want the MI.
So where is her? She will appoint her own lawyer.
Yes, said, madam.
Correct. Let her say that. But then if
Yes,
she
did
does
say
not
that.
appoint, it's the end of story. You cannot keep a court at ransom by saying, I will appoint.
My lord, this is what is happening. My lord, previously we were appointed. Rima Kumar
All right.
came in. Again we were reappointed.
Only Ajay Sen's appeal, there's a application for suspension of sentence.
Rima is representing this appellant. Mili. Hmm. Has this order been communicated to the convict? এটা কি no compliance report কেন? Next matter.
He is not available, Lordship.
Yes, who was filed for suspension?
My lord, item number 57, I'm led by Mr. Milan Mukherjee, my lord. Bring.
He's in custody for about 1 year. However, he was granted default bail, 90 days bail during trial. This is 302. There are 4 eyewitnesses.
My lord will kindly take it up on the next week, my lord. Mr. Mukherjee is appearing, my lord, in 57. Fulvas
No, any report? One second. For what? What report?
Detention period and one of the health condition.
What health condition? Whose health condition?
Appellant number 2, my lord, in item number 4.
আচ্ছা এখানে once again এখানে multiple accused আছে. Why no report that whether other convicts have filed? আর আছে কিছু? কোথায় রিপোর্ট যে অন্য কনভিক্ট ফাইল করেছে কি করেনি? All the appellants are filed. আচ্ছা এই যে এখানে মিলি সেনের একটা মিলি পাল কনভিক্ট কে কমিউনিকেট করার কথা, কিভাবে তুমি কমিউনিকেট করেছো অর্ডারটা? কিভাবে কমিউনিকেট শোনো in 57 who is unwell?
Pintas Mir.
Huh?
Pintar Mir, appellant number 4.
Pinta
Mir.
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 দেখি কি রিপোর্ট। পিন্টা মির
আজকে করবে না তাই
ये पैसा लेकर लिखता है सेम रिपोर्ट ही has been in another case. Medical report of Mir Nurul Hassan is perused. Report shows that he had been treated at nephrology OPD SSKM hospital. Head of the department nephrology, SSKM hospital shall undertake a medical assistance, undertake an assessment of the health condition of the convict and submit report with regard to his state of health, prognosis, and nature of treatment, nature of treatment prescribed, and the prescribed nature of treatment, and the nature of treatment, nature of medical treatment. Report shall be filed on adjourned date. Matter will appear 3 weeks hence, 4 weeks hence.
I'm grateful to your lordship.
Everything, Mr. A, all appeals arising from one order of conviction will appear whether they file or not. They go together, they come out together, they travel together. They are a family. It's a family of litigation. So they don't get separated. Otherwise, your prosecutor's office will not be able to apprise a judge that he is hearing an appeal where another appeal is pending in the department. So it will create miscarriage of justice. And our department has therefore been instructed, wherever any appeal of a multiple accused case, the department shall forward a report how many appeals from the same judgment has been filed. And if they are more than one, all judge appeals will be listed en bloc. Next.
58 to 61.
Malad 58, Malad, I am for the petitioner. Malad, standing on same footing, Malad, one person has been granted bail by your lordship. Malad, statement of co-accused.
All right.
60 has been rejected. 60 I am for the appellant.
60 is different. 60 is different.
Oh,
Malad,
59 has been allowed.
Allowed 59 and 61.
I am standing on similar footing with Sheikh Safiq. Malad, your lordship.
Sheikh Safiq is?
Sheikh Safiq
is 50?
61.
61. All right.
59.
You are Harasek.
Yes, Harasek.
You are renewing suspension prayer or?
No, this is the first time.
First time.
First time. Page 60.
Let us see the order sheet.
ওই দিনকে আমার ওখানে অর্ডারটা রোকসের আলী করে করা আছে ওই দিনকে আমার
Harashik Mr. A, no order was passed.
Yes.
We have considered the evidence on record. No narcotics was recovered from the appellant.
This is not narcotic, my lord. This is not narcotic. This is a case of decoity, my lord. Decoity as well as murder. My lord, your lordship would see.
All right. Acha, we have considered the evidence on record. Appellant stands on the same footing with Sheikh Safiq, whose sentence has been suspended. We have considered the evidence on record. Appellant was implicated on the statement of co-accused Naim before second investigating officer PW20. contending that the statement of co-accused before police officer is inadmissible in law. Convict Sheikh Safiq has been enlarged on bail. Petitioner is entitled to similarly circumstanced and is entitled to similar relief allowed.
My lord, only my lord, I remain in custody, know him.
So know him, you are caught. What can be done?
Now, my lord, in that even
Paper books are ready. Paper books are ready. Matter appeals shall be added to the list in the monthly list of March 2025. March 20. All paper books received?
No, my lord. Single paper book?
You appear all? You have all got paper?
No,
book?
I haven't got. I'll collect.
Appellants are directed to collect the paper books in the meantime.
Paper book here.
Why didn't you type it out? So we are getting Ranjan, Hussain and Nobial not named in FIR and no specific overt act.
But they were present and assaulted. That is the common thing. Yes.
Now with dangerous weapons, how many injuries found on the victim?
Malud, kindly take up the records of the first item, Malud, 224 ones, page 31 is the deposition of the autopsy surgeon. Item 62 times. Brand one. That is the deposition of the autopsy surgeon. PW 11.
Now, Mr. See one thing. Apart from an abrasion on the elbow, all the injuries are on the head, purporting to relate to the assault by Lal and Sukur, right?
With stones.
With stones. Okay. Take them.
I want to also kindly see page 35, the deposition of the eyewitness, PW 14.
14, that is.
So far as the Lal Muhammad Bhuiya, the assault is concerned, Millet, the version is.
Mr. Lahidi, we are not hearing an appeal. We have tried to impress on you This is not an hearing of appeal for your acquittal. We are just seeing whether you are a prima facie candidate entitled for an interim relief. And we have indicated to you at the pain of presenting judgments of the Supreme Court that you have to make out a palpable case which is in your favor. So that whether 14 could have seen, etc., will be seen during trial. Appreciation of evidence not required.
Well, it only mitigating circumstances so far as Babar and Yasin Bhuiya, Yasin Bhuiya has pleaded that in his well, at the point of hearing sentence, hearing the sentence, but Babar, that was not pleaded. Maybe file a supplementary for Babar.
Tell us, what do you plead?
Babar has aged parents, 85 years old.
For that, you will be given suspension of sentence.
This is in terms of Justice Pardiwala's
judgment. Justice Pardiwala says that if aged parents are there, palpable case, we will ignore and give. You go to the Supreme Court and get it. Mr. We have made it very clear. Yes, now tell us, Mr. Lairi, what is your contention about Shukur and Lalchand?
Shukur and Lalchand, I'll just indicate to one thing, Millet. Irrespective of the anomalies attached to PW14, there are contradictions so far as this involvement of these persons are concerned.
Correct. We have followed. How many were named in the FIR? 41.
41 and others, yes.
41.
Yes.
Charge sheeted?
34, Millet.
34.
34. Convicted? 7.
7.
Appellants contend
13. 1 3.
13.
Appellants contend the prosecution case is based on shaky foundation. PW14 is the sole eyewitness and informant. In the FIR, he did not give an impression he was an eyewitness and implicated 14 individuals.
In the FIR, 41 individuals.
41 individuals. Charge sheet was filed against 13 and 7, that is the appellants, have been convicted on his sole deposition. Admittedly, the witness is not wholly reliable. They contend the witness is wholly unreliable and was not present at the spot. Full stop. It is also argued that the appellant only present at the spot. It is also argued that there is political enmity. That was argued, no? Yes, yes. There is political enmity which resulted in false implication. Accordingly, you were on bail during trial? Appellants were on bail during trial, which continued for more than a decade. Hence, they pray for suspension of sentence. Mr. Bhattacharya, Ms. Gaur, senior government advocate with Mr. Bhattacharya opposed the prayer. They submit the appellants had gathered at the spot. Appellants had gathered at the spot Appellants and others had gathered at the spot with various arms and weapons. Most of the appellants, all the appellants except Ranjan Mondol, Hussein Ali Mondol, and Nobial Mondol are named in the first information report. In court, PW 14 is the first informant. In court, he stated that the appellants had brutally assaulted all the appellants assaulted the victim. Appellant Lal Mohammad Bhuiya and Shukur Bhuiya struck him with a stone on the head, resulting in his instantaneous death. PM report indicates head injury, lacerated injury on the head, corroborating the ocular version. Stop. Accordingly, they oppose the suspension of sentence. Full stop. Appellants have been tried. On a charge under section 302 read with 149 IPC. That is 149 IPC. To prove a charge, to prove such a charge, the prosecution has to bring home this charge. Prosecution must prove that the appellants were members of an unlawful assembly whose common object was to murder. Members of unlawful assembly whose common object was to murder. Full stop. Specific overt act of the appellant, of each of the appellant in the assault is not necessary. PW 40 is not necessary. It is also relevant to know PW 14 is the informant and eyewitness. In the first information report, he had indicated the presence of Babur Ali Kotal, Yasin Bhuiya, Lal Mohammad Bhuiya and Shukur Bhuiya amongst 41 named accused. During investigation, charge sheet was laid against 13 persons, noting and others were discharged. Learned counsels referring to this diminution in number of charge sheeted accused, learned counsel contend PW 14 is an unreliable witness and had incorporated names and had falsely incorporated a number of names, and had falsely implicated the appellants in the crime. Full stop. It may be relevant to and had falsely implicated the appellants in the crime. It is also argued that he could not have been an eyewitness. We have considered the evidence of PW 14. He unequivocally stated on oath that he had witnessed the incident where a large number of persons, including the appellants, had assembled at the spot with arms. Thereafter, they had assaulted the deceased. Thereafter, they had assaulted the deceased. And Lal Mohammed assaulted the deceased. Lal Mohammed Bhuiya and Shukur Bhuiya had struck him with a stone on the head. Full stop. Mr. Lahiri contends this is a contents attribution of striking the victim or the deceased on the head by Lal Mohammed and Shukur is an embellishment which does not find place in the first information report. Which does not find place in the first information report. Good stop. While considering a prayer for suspension of sentence, the court is to while considering prayer for suspension of sentence in a case involving life imprisonment, the court is not required to undertake a meticulous appreciation of the evidence, but meticulous appreciation of the evidence, but would scan the evidence, but would address itself to the but would address to the issue whether a very palpable case in favor of the appellants are made out in favor of the appellants is apparent from the records, as indicated earlier in a chart. As indicated earlier, PW1 allegation, as indicated earlier, ocular evidence, ocular version of PW14 is ocular version of PW14 that Lal Mohammed Bhuiya and Shukur Bhuiya struck the victim, struck the deceased on the head with a stone is corroborated by the injuries to 1, 2, and 3 in the deposition of PM Dr. PW11. PM Dr. PW11. It is also relevant to note now with regard to the other appellants, it is apposite to reiterate they are charged as members of an unlawful assembly and specific overt act, and in the event the prosecution proves their membership in the assembly sharing common object, specific overt act need not be established. Appreciating evidence of PW14 from we have scanned PW14 from that perspective to determine whether any palpable lacuna vis-a-vis membership of the other appellants in the unlawful assembly is made out. Babar Ali Kotal, Hussain Ali Mondol, Babar Ali Kotal, and Yasin Bhuiya have been stated to be members of the assembly, unlawful assembly, in the first information report, which corroborates PW14, which corroborates PW14's deposition in court and convincingly establishing, which corroborates PW14's deposition in court against them. But membership of appellant's membership of Ranjan Mondol, but presence of Ranjan Mondol, Hussein Ali Mondol, এই ওই আর কি রাজন না রঞ্জন গো
Appellant's name is Rajan.
রাজন
He has interchangeably used Ranjan as well as Rajan in his deposition.
so which is now more popularly used blank Mondol presence of Rajan alias Ranjan Mondol, Hussein Ali Mondol and Nobian Mondol is not noted in the elaborate first information report citing 41 accused. Though it is though prosecution contends there the FIR also refers to unknown others. It is nobody's case that Ranjan Nobial or Hussein Ali were not known to PW14. Their presence was stated for the first time in court when PW14 was examined during trial. This, in our estimation, is a palpable lacuna apparent from the records, which does not call for weighing of evidence. Full stop. Accordingly, we are inclined to suspend the sentence. Call for evidence. Full stop. We are as the sentence is, as the offense is one of murder, attracting life imprisonment. We are not impressed by Mr. Dotto's submission that appellant Babur Ali and Yasin needs to be favored prayers for suspension of appellant Babur Ali and Hussein need to be favorably considered in view of the ailments of their aged relations. Full stop. In light of the aforesaid discussion, we are not inclined to suspend the sentence of Lal Mohammad Bhuiya, Shukur Bhuiya, and Yasin Bhuiya. However, Babur Ali Kotal and Yasin Bhuiya. However, in view of the palpable lacuna indicated in the prosecution case vis-a-vis Ranjan Mondol, Hussein Ali Mondol, and Nobial Mondol, we suspend their sentences subject to conditions.
Something.
Article 142 में करेगा जो भी करेगा we are not interested.
Maybe Rajan Mondol.
अरे जा वही तो appear give that name correct.
Rajan Mondol.
In your petition and it
is Rajan Mondol.
It is Rajan to. Thank you, Mr. Bhattacharya. In errors, defects be ignored, paper books be prepared with info. In 2019, now after 7 years.
Yes, after 10 years almost.
Trial, the statement was, evidence was recorded after 8 years.
Right. 12 after 7 years.
That is why they forget.
Yes, yes.
What is it? In 41 named accused, if you don't name someone,
That is the
that is a
difficult.
palpable omission.
Because once I'm
That is a
naming
palpable-
specifically 41 person.
41 you name and others, unknown others. Now, these are not unknown others.